And before we get to what we were just discussing, I want you to listen to the latest testimony from Donald Trump, bravely delivered on a fawning right-wing radio show today, in which Donald Trump tells a very big lie. It's the kind of lie he's told before. Let's listen to this.
So if you have to go to trial, will you testify in your own defense?
Oh, yes, absolutely.
You'll take the stand.
That I would. That I look forward to.
No, I think that obstruction charge is going to get the trial, Mr. President. I think that.
I'll testify.
Okay, if you do, and they ask you on the stand, did you order anyone to move boxes? How will you answer?
I'm not answering that question for you, but I'm totally covered under the law.
Okay.
If you read the Presidential Records Act, just read it. You take a look at it. I'm totally covered under the law. It's a civil act. It's civil.
Bradley Moss, so I guess Donald Trump's going to testify because he would never lie about that on a radio show.
Yeah, there's no way on earth Donald Trump is ever going to take the stand. His lawyers will throw their bodies in front of him before they ever let him get on that stand. The man's a walking perjury machine. He would never put himself in that position. But what was interesting from that interview with Hugh Hewitt was that Trump kind of made a confession here about how he doesn't understand the law, and that could come back to bite him if this gets to trial, where he says, so I can do whatever I want. Everything comes to the Presidential Records Act. I can do whatever I want. Well, that's not the law. And there's going to be jury instructions, no doubt, if this gets to trial and gets to the jury verdict, in which the judge outlines how that is, in fact, not the law, how the law still applies in terms of obstruction provisions, in terms of the Espionage Act, that everything Trump was spouting off and what he seems to believe, despite what his lawyers kept telling him, is not, in fact, accurate. And that will be his undoing if this gets to a verdict.
Harry Litman, Stanley Woodward's filing today in the case is a very, very, very strange filing for many reasons. But the essence of it is he is asking to have his own client, Walt Nauta, examined by the judge to assure the judge that Walt Nauta sees no conflict of interest with Stanley Woodward representing him. But more importantly, even than that, he's asking that the star witness in the case be banned from testifying in the case because he says it was unfair for Jack Smith to use a Washington, D.C. grand jury to obtain that evidence from that witness, which produced the superseding indictment, the extra indictment of Donald Trump and his co-conspirators in Florida.
Yeah, and the way you put it, it's how he puts it. There's no case authority at all. He just says the proper remedy is to exclude him. But excuse me, there's, that this is the star witness. And yes, he asked for the Garcia hearing, but I think it's more accurate to say he agrees or concedes they've got to do it. Woodward is really up to his ears, not simply with these two, though it's the most vivid example, but he's paid for by Trump. He's been representing everybody. And so-called employee number 4 is Taveras, is someone he did represent. Then Taveras went back and got a public defender who told him, you know what, you're crazy. You should tell the truth and cooperate. And that's demonstrable. You know what else is demonstrable? The same is true for Nauta and De Oliveira, the other two, that they are letting themselves go forward with Woodward's help on charges of obstruction when they could almost certainly cooperate and at most only have to face liability for false statements. In order to serve Donald Trump, it's just baffling and just completely against their own legal interests. We'll see if they now follow suit, because there's going to be this dynamic. The two of them who can't talk to each other are wondering who's going to go first. It's sort of a prisoner's dilemma. Who will run to Smith? Let me cooperate as well.
So, Bradley Moss, there is the oddity of the defendants, the client's dilemma. But what about Stanley Woodward himself? What is his obligation in this situation? If he's aware of a conflict of interest that seems very apparent to everyone looking at this, doesn't he have an obligation?
Yeah, so all lawyers, your ultimate obligation is to the client, not to whoever pays the bill, but to the client. And so in this context, Stanley Woodward has to be convinced for himself that he has done everything reasonable, his proper due diligence to ensure that he's serving Walty Nauta's interests, that he properly served Tavares' interests when he was representing him, that he's doing for these various other individuals. I believe even Peter Navarro in the contempt hearing or contempt trial right now is his client. He has to undertake those proper due diligence efforts to ensure he is representing their interests and advocating their rights and interests, and not considering someone else, not putting them at risk in favor of whoever's paying the bill or another client.
Harry Litman, he's just going to go ballistic. That is on an audio recording made by one of Donald Trump's criminal defense lawyers talking to another Donald Trump criminal defense lawyer about what Donald Trump would do if anyone tells him he has to obey the law about the documents that are illegally in his possession. He's just going to go ballistic. Is that evidence from the lawyer's notes, the audio recording and the transcript of those notes? Is that going to become evidence introduced in this prosecution?
You bet. And it's another example. People who deal with Trump know they better get a tape and use it. And Corcoran knows the reason he did it right away is under the evidence code. If you immediately, it's called a present sense impression, but that makes it admissible. And it's another example, going back to Jim Comey and Raffensperger and Mike Cohen. People know who deal with Trump. They better get a tape, lottie. And it turns out, in fact, that these are situations where Trump thinks it won't become evidence, and it will. It's going to be incandescent evidence. We already had the evidence of what if we don't comply, and now this caps it, where we know he pays no attention, Trump, to what Corcoran's saying, and then another lawyer comes up and says he's going to go ballistic. He'll say not do it at all. It's all admissible, all against Trump, and man, that sort of 45 seconds of dialogue is just murder for Trump.
Yeah, Bradley Moss, it's hard to imagine. I just don't understand how the defense could survive that kind of evidence coming in.
If it gets in, yeah. If this gets to trial and those kinds of pieces of evidence are there, Trump is toast at trial. This whole case, and we've been saying this in the beginning, hinges on the pretrial motions. And one of them will be, in this case, in terms of Corcoran's notes and everything else he testified to, it'll be a motion to suppress, basically trying to reverse the original grand jury judge decision with respect to allowing this in, basing it on the the crime fraud exception to attorney-client privilege. That's going to be relitigated as part of pretrial motions. Trump has got to get that stuff out, because if he does get in at trial, yeah, he's toast. It's over.
And he has the most favorable judge he could find in the country who might try to rule in his favor on those things. Harry Litman, Bradley Moss, thank you very much for joining us again tonight. Always appreciate it.
Good night.
Thank you.
Thanks, Brad.